Very good morning and welcome back to Set 6 of Indian Penal Code 1860. Myself, I am Manoj from Maxacon, wishing you all Tamil Puthandu Vathakal. And I would request all of you to kindly subscribe the YouTube video and press the bell icon so that whatever is being populated immediately will come to your desk. In set 6, let us learn forgery. Forgery means someone is making a false document or false electronic record with a purpose to cause damage or injury to the public, or to support any claim or title, or to any person to part with property, or to enter into any express or implied contract, all with an intention to commit fraud, or fraud may be committed. This is what we say, that he commits forgery. So in forgery, you need to understand, one, somebody has to make a false document or false electronic record. In it, there are around four purposes: either to cause damage or injury to the public, second, or any person to part with the property, or any person to enter into an express or implied contract, all with an intent to commit fraud. That is what we say as forgery. Now, the making of a false document is defined in section 464, which is not part of our syllabus, and its punishment is given under section 465, imprisonment which may extend to 2 years, or with fine, or with both. Now, there are three important case laws. Let us study about it. Here, Ramachandran versus State of Kerala in 1922. Here, Supreme Court has said, if you want to constitute it any offense as a forgery, the document must be made with dishonest or fraudulent intention. So, dishonest or fraudulent intention, that mens rea, that is the important event in to constitute any offense as forgery. Similarly, in Parminder Kaur versus State of Uttar Pradesh, where in 2009, Supreme Court held that alteration of a document may be clerical mistake. That does not make it a forged document. To become a forged document, it must be made for some gain or objective, that is dishonest or fraudulent intention. It is once again a reiteration of same thing which has been there in the Ramachandran versus State of Kerala. The next case law is a bit interesting. It is Balbir Kaur versus State of Punjab in 2011. Balbir Kaur was an elementary training teacher and she was a petitioner, and the case was she furnished a certificate to get employment which was found to be forged, because the school where she had been working, the certificate what he had given with respect to that school was not recognized for the period given in the certificate. Later on, the appeal reached the Supreme Court. Supreme Court observed that the certificate did not anywhere say that the school was recognized. So it was held that mere indicating the teaching experience of the accused per se cannot be said to indicate wrong fact. It is not a forged document. So the direction which was issued for prosecution is liable to be quashed, and she won the case. Next is a small illustration. Here from the picture itself, A got a letter of credit upon Z for rupees 10,000. And what he does is that he adds 1 0 to that letter of credit and endorses it to B. Now, do you feel that it is right? A committed forgery. This is an example given in the book. With this, the forgery part of set 6 is over. Thank you, and let us look forward to set 7.